sexual crime sponsor. Open up the hearing on CACR15 and recognize Representative McKellar, who is my sponsor, and who has written testimony, apparently.
Has been passed around.
Yes, and it has been passed around. Thank you.
Thank you, Madam Chair. And members of the committee, I'm introducing today a constitutional amendment proposed to protect from warrantless searches people's effects and property. I think that the first question that really this raises is it kind of a restatement of the constitutional amendment we just passed, Article 2B, and I submit that it is not. That the Article 2B has kind of a fatal flaw in it that doesn't protect the things that I'm trying to protect in this constitutional amendment, which stems from what's called the third-party doctrine. It has been used for many years, and it kind of designates what is and what is not private information, private documents, et cetera, and so when we reference private information and stuff in that Article 2B constitutional amendment last time, we still have accepted that the current understanding of what is and what is not private. And so many people are not really familiar with the history of the third-party doctrine and the nitty-gritty details of that. I have asked a few experts to testify on that aspect, the history, and going into why it is the way that it is, and why this is potentially a good way to address that issue. But in a sense, the third-party doctrine is just anything that you've shared with a third party. It doesn't matter if you have contracted that information is to be kept confidential. You have no expectation of privacy, and the Fourth Amendment doesn't apply. Unless the government has sectioned off that area of things like your interactions with your lawyer or doctor, et cetera, there are certain things that it does apply to. But if you have a Google Doc, or if you have your diary stored in the cloud that isn't your own server, you've shared that information with a third party. And the government does not need to get a search warrant. They can do some lesser standard, such as a subpoena, et cetera. That doesn't necessarily even say that you committed a crime, but that that information might be helpful in some prosecution. It doesn't even have to be a prosecution against you if you get that information. And so in New Hampshire, there's a couple Supreme Courts that set rulings that say stuff like our law regarding information on voluntarily exposed information to third parties is in line with the protections afforded under the Fourth Amendment. And so we haven't really differentiated ourselves from the federal interpretation, which is where this third-party doctrine comes from, whereas other states, like Arizona, have decided that our interpretation is going to be different, and or their interpretation is going to be different. And so in another case, the Supreme Court said that they were persuaded that the equities so strongly favor protection of a person's privacy interest that we should apply our own standard rather than defer to the federal provision. And so there is kind of a desire to potentially protect more than what the federal government is doing. And you are allowed to do that. The federal government is kind of putting a baseline of protection, and the states are able to increase that protection. So the final quote that I would use from a different decision is that they encourage the legislator to examine whether telephone billing records should be protected under the reach of a prosecutor's subpoena. And this, I think, all can be summed up in that there is some clarification on when you're sharing information and how and what we want to protect. And I think that that my proposal is to just protect. There's other bills that may protect other things like your DNA data, et cetera, but I am proposing that that assumes that those things are the things that you want to protect. And it is kind of designating, like the government is saying, we are going to protect these things. If you want to protect something else, that's not one of the things that's on the list. And so what I'm proposing is that we empower the people to set those terms of privacy with their businesses they do business with through a contract. They have a privacy clause in that contract, and if that business wants to offer a high level of security, which some companies like Apple and stuff are trying to create, then they would be able to protect more than they currently are able to. Right now, if you read privacy statements, they're saying that they're going to protect your information up to subpoena. And the reason why they're doing that is because they can't go further. Under the third-party doctrine, there's no protection. Really, they would have to spend large amounts of money to try and fight a subpoena and would probably still lose because of the interpretation of the third-party doctrine currently. And so what I am trying to do is say, in New Hampshire, we're going to honor your contract and say, if this company wants to just do a level of subpoena, the government's fine with that. If you want to go all the way up to a search warrant for that information and show that you have done something that could potentially be a crime before they reveal your information, then we are allowing those companies to do that. This isn't a demand of the companies. This is it actually is a restraint on government from breaching legal contracts with people like your internet service provider or any real company that you do business with, whether it be the sign-in sheet at your local gym or your Uber ride or whatever the case may be. If those companies want to offer that additional protection up to a warrant, I say I am proposing that we respect that. And I am happy to answer any questions.
Thank you very much. Representative Woodbury has a question.
Thank you, Madam Chair. I'm trying to understand something, and I guess I'm going to start with a hypothetical that means something to me, and hopefully it'll straighten me out. Let's assume I'm a thief. I go down to Atlanta and I break into the safe and I steal the secret formula for Coca-Cola and bring it back to my house. And then I talk to my friend, Representative Gordon, who's going to mix up a batch for me. And I give him the information. What's protected there? Am I protected? I've got the formula at my house.
Right.
I think I should demand a search warrant before the police come and take it away from me. But what happens to the information when it's in Representative Gordon's hands and he's getting ready to mix up a patch?
Absolutely. Absolutely. There's so let's assume that you've had a contract with him saying you're not going to reveal this to anyone. That we have this stolen information and we're going to make a batch of our own. And under this rule, that contract that you have to keep that information private is what is called in the common law an illegal contract. You're not allowed to, that isn't going to be recognized by the state as a valid contract. And so him turning informant and saying that you have this and them using that as evidence to get a search warrant for your premises is completely within the bounds of this this regulation. Yeah.
A follow-up or?
Yeah, it's actually a follow-up, yeah.
No, I just want to know, Representative Woodbury had a follow-up.
I'm all set. Thank you.
Okay, then Representative Griffin.
Thank you, Madam Chair. Thank you for taking my question. In follow-up to Representative Woodbury's question, keeping in mind, of course, that I will be at Representative Gordon's house drinking the Coke because I can't stand Pepsi. What about if Representative Woodbury contacts Representative Gordon through the internet, using the cloud as the server to communicate, I am sending you this formula, and you are to keep it confidential? Does that change the transaction at all? Because now it's out there.
No. Because the third party is really anyone that you share that information with. And if it's an illegal contract, because the purpose of the contract is to conceal a crime, yes. If it's to conceal a crime, that is not a valid contract, and so all the provisions of it do not need to be honored.
So your answer to Attorney Woodbury was, Attorney Gordon's stuff would still be gained for purposes of investigation, because the
Right.
contract to keep it confidential was.
Right, but the contract with your service provider
Yeah.
is not an illegal contract, you're just trying to get service, right?
Right, so.
And so that would be protected, but
Exactly.
not the protection for Gordon.
Right, but I think I think you've clarified my answer.
Okay.
Thank you. Thank you very much. Are there any other questions? Yes, Representative Burke has a question.
Trying to figure, I know that third-party doctrine is highly debated these days as a concept. And the Supreme Court, either in the Carpenter case or otherwise, has been defended. So, let's say you've written out a confession to a crime, and you send it to me. Are you and I have it on my desk, and we send it to you. Are you suggesting that you still have some expectation of privacy after you've mailed it, such that the police will have to get a warrant to protect your privacy from taking it off my desk?
So what I'm trying to do is protect the contract. And so if you're saying that you gave this confession, let's say, and you said I didn't want you to release it until I've had my lawyers edit it or something like that. And so you're contractually obligated to not release that information, right? And I'm still keeping.
Go ahead.
So if I just give it to you with no conditions, then there is no contract to keep it secure. So if you read the language of my bill, it says a legally enforceable contract in which you limit that the information is to be used for only a limited purpose and otherwise to be kept confidential, right? And so if I gave it to you and I didn't demand that you keep it confidential for any reason, and the condition on me giving you that information was not that you gave it confidentially. So that is, I believe that case is not, I think, I am not a lawyer, so I would have, there's a couple of lawyers behind me that would be able to better answer whether or not they believe that that was an illegal contract. Personally, I don't think it's an illegal contract because it's not in the commission of a crime, or the purpose isn't part of a crime. But I also think that in your question, you didn't have a contract in which it limited the giving of the information to the police in any situation. So.
Representative Wilbur has a question.
Thank you. So if I'm understanding this properly, what you're proposing only applies to things that meet the formal definition of a contract. That there's such things as consideration and specific wording protecting privacy. Is that correct?
Contract is in the language of my amendment. So I would be only protecting what is considered a contract. Now, you can have a verbal contract with someone, right? Doesn't have to be written and notarized by, people. So any legally enforceable contract would be protected.
I think you mean an oral contract.
Sure.
Since verbal is using words which could be spoken or written, whereas oral is
Right.
unspoken.
Thank you, Madam Chair.
I just want to make sure that we're clear on what we mean. Are there any other, yes, Representative Harper has a question.
Thank you, Madam Chair. A lot of times we pass constitutional amendments, then use the RSAs to define them or to clarify them. Why aren't you just clarifying our right to privacy and implementing this as a House bill instead of an amendment, which the hurdle to get that through is pretty ridiculous?
So I believe that the protections are, a little bit, there is a significant amount of additional protections by having it as a constitutional amendment, in that it can be edited and changed as easily, and so it's really a commitment. But also, I think it opens, is going to make I think that it's going to really make it clear that we disregard the interpretation of the federal constitutions, and that it wouldn't supersede. Because if you said, okay, we have this RSA, maybe it's unconstitutional because of the current interpretation of the Constitution, right? And so you would have to change the interpretation of the Constitution to make that honoring of that contract constitutional. Is my feeling that it's possible that it would be considered unconstitutional based on the current interpretation of our Constitution, and that it's kind of risky that the Supreme Court would interpret it the way that we intended it to be interpreted. Okay.
Thank you.
Absolutely.
Thank you very much for all the time. And Representative Gordon, question. How's the Coca-Cola? How's the Coca-Cola?
How's the Coca-Cola? It's great.
He's a Pepsi drinker.
The current law is that if you basically share information with a third party. It doesn't have constitutional protections under our constitutional reforms. The problem I'm having is with the language here, because it says, including information provided as part of a legal enforcement contract. So, provided seems to indicate that it's in exchange for something, or information requested, as opposed to simply shared. And it would seem that if I wanted to go beyond constitutional protections, that I would want to say, including information shared with a third party as part of a legal enforcement contract, which would get to the heart of the issue.
Representative there, I know you have
Yeah,
some people who are following.
Yes.
If you feel uncomfortable
I
answering, you
am
don't
not,
have to.
I'm not necessarily uncomfortable with the change, but I kind of would have to think about the definitions of these words and really kind of dig into what the ramifications of that change would be. And so I would definitely ask that some of the experts would weigh in on that.
I'll wait and ask for
Any other questions? I don't see any. Thank you very much for
Thank you.
taking the time to explain this to us. The chair recognizes Robert Davis, who is from Illinois. Welcome to New Hampshire, and representing the Heartland Institute. Stay around, we have a presidential primary, and it's very interesting.
Madam Chair, members of the committee, thank you for taking the time today. I know I'm with the Heartland Institute, and we're looking today to ask you to consider supporting CACR15, the amendment to the state constitution that would protect the privacy rights of New Hampshire citizens from unreasonable government searches, as well as seizure of their electronic data residing specifically with contracted third parties. As we mentioned before, New Hampshire voters recently approved an amendment to the state constitution in 2018 that ensured an individual's rights to privacy from government intrusion. However, this does not necessarily protect the privacy of their data held by contracted third-party services. So this amendment seeks to stop that gap. And then, as we discussed, recent Supreme Court cases such as Carpenter, as well as United States versus Miller and Smith versus Maryland back in the 1970s, have had generally narrow rulings and have left the third-party doctrine open to interpretation. And in regards to that, a lot of state governments have begun to address the issue. Specifically in Utah, last year in 2019, they passed the Electronic Information or Data Privacy Act, which required a warrant for accessing Utah residents' private information stored with third parties. So it's an emerging issue, and the answers may not be easy, but it's starting to come to the forefront. And then with Supreme Court case law not yet caught up with the current practices, there's still a lot left open to interpretation. And essentially this amendment is aimed to provide the foundational principle that a citizen's electronic data is confidential and protected by legally enforceable contracts. New Hampshire voters should have the opportunity to decide who owns their data, regardless of where it is stored. Ultimately, it should be left up to the consumers and the companies to determine the nature of their relationship. The government can enforce the contracts if there's a dispute between a company and a consumer, but they should not dictate or interfere with those contracts. And we just believe that limited government in this regard might be the best way to address all the parties concerned with that. As we said, this is a new frontier. The issues may not be straightforward or easy, but we just want to make sure that the rights and civil liberties of all New Hampshire citizens are protected and addressed. Thank you very much.
Thank you very much, Representative Woodbury.
Thank you, Madam Chair. I'm indebted to Representative Griffin and Representative Gordon for helping me understand this a little better, I think. If I write a letter to somebody and send it by U.S. mail, the information that I have in that this amendment, it seems to me I could sort of sanitize that by, instead of writing a letter, I would simply write an email, because it then becomes part of my contract with my email company. Is that what the intention is, that you can sort of sanitize the situation simply by using an electronic medium versus an old-fashioned snail mail one, or is it more so?
I think it goes to the heart of that, just with the times, how they've evolved. Letters just aren't as popular as they were, as they used to be, and then with electronic mail just being so prevalent, this amendment would just make sure that that specific aspect is covered. And email servers and internet service providers are definitely the main consumers, or those are the main avenues that consumers will use. So I don't exactly would have the exact, I can only speculate on the exact nature of what would define some correspondence in that nature, but since it would be an electronic form of communication, which would then have the email service provider would have access to, the language of the amendment would be able to cover that. And I can follow up with you and provide you with more specifics if you would like regarding that.
Thank you, Madam Chair.
Representative Brennan's question.
Okay, so just to clarify, so I can understand myself what Representative Woodbury is saying, to follow along that analogy, if I send you an email, you are free at any time to disclose the email that I sent you, and this would not prevent that. But the internet service provider could not provide that.
Not without my permission, because I understand it. If I was the consumer willingly providing you with the
So
email that I had.
the service provider could not provide it without me, the sender, if this passed, agreeing to it.
I could only speculate on the exact nature. I would, just looking at the language again, I'd have to look on that, but just based on what is being presented, I would say yes.
Representative Chase.
Thank you. Madam Chair, thanks for taking my question, because I am trying to figure it all out, but still confused. Is this like the issues that we've been having with, say, shootings and iPhone not giving the phone information?
That's certainly a recent area of discussion in regards to that. I know especially with the U.S. government looking into Apple, looking into that. I know there's been concerns raised on why they would do that, whether they should, because the reporting on that seems that they could just ask any third party, that organization that specializes in that, but that they're asking the manufacturer specifically. I know they have different reasons for asking that. I'm not exactly sure how that would be applied with that, and I can definitely defer to other witnesses when it comes to that, but I know it's a fine line to walk, and as thinking of the manufacturers for Apple, they have the decision to make, especially if we're promoting, if we're marketing that our products are private, none of our consumers or our customers' information will be, without the proper procedure of a search warrant approved by a judge. As long as that due process is maintained, they're not just going to give it out to government agencies without that search warrant. So short answer is I believe that will still apply, and I wouldn't be able to give a definitive answer, but I can definitely follow up.
You follow, and I just follow up real quickly. Okay, so I understand now, so that's the manufacturer, but it would be the provider of the phone service, is what this is more about?
I could only speculate on that as well. I can look to see exactly what the parameters, who would be included with that, and I can definitely follow up.
All right, thank you.
Yes, ma'am.
Thank you.
Representative Sylvia's question.
Thank you, Madam Chair. Thank you for taking my question. As we drift into these contracts that are based in other places, in fact, I think we have one that we signed at the state level here that's a service provider in Canada, and the law is based in Canada. Would there be any protection of this amendment to the Constitution that would affect that?
With foreign providers specifically, or?
Anyone out of state?
I would believe it would. I'd have to look again at the language again, and I would have to probably defer to other witnesses when it comes to that. But the internet is very amorous, very flexible, and hard to define, and obviously with different connections, servers can be located in a different state from where you are. So obviously that's part of the issue, just trying to find definitive solutions when it comes to that. And that can definitely be something that I can provide further research on, especially with foreign governments or foreign countries that they're hosting servers, as well as providing services with citizens in New Hampshire. That'll definitely be something, an ongoing part of the conversation.
I just want, we'll call on Representative first, but I neglected to ask the prime sponsor something, and that is, the origin of this particular language. Did it come from Heartland? Did it come from Mercator? Where did the initial language?
So I worked with the Center for Legalization of Privacy. That's another speaker today, and we really worked on drafting the language together.
Thank you.
Yeah.
Just didn't know if we were asking you questions that could better be asked of someone else. But Representative Birch had a question for you.
Thank you, Madam Chair, and thank you for taking my question. You mentioned Smith versus Maryland. I thought we'd talk about that for a moment. As I recall, Smith versus Maryland, a robbery victim was getting all sorts of harassing phone calls, called the police, and essentially the police put a pen register on the victim's phone and was able to
What's
trace
the
that.
question?
Trace that back to the maker of the calls. There was no warrant or anything. The Supreme Court held that such a procedure didn't involve any expectation of privacy. Are you suggesting that that was wrongly decided? Do you think that if somebody's making harassing phone calls to someone, that the recipient of that goes to the police, there needs to be a search warrant to protect the caller's right to privacy?
I'm not aware of enough details of the case to make a definitive answer with that. I know the ruling, the court concluded that there was no reasonable expectation of privacy when the government obtained a list of those phone numbers. And that just reading, just a quote here, quote, "They know that they must convey numerical information to the phone company and cannot harbor any general expectations the numbers they dial will remain secret." So that's, unfortunately, that's the extent of my understanding, but that was kind of the basis for what the court ruled. But unfortunately, I probably shouldn't make a definitive conclusion on that.
Thank you very much for your time. Appreciate it. The chair recognizes Jennifer Huddleston from the Mercatus Center at George Mason University.
Madam Chairwoman, my colleague has copies of my written testimony and you distribute them to the committee.
Of course, if you would just give them to Representative McLean at the end of the table, he'll help you. Thank you.
Good morning, Chairwoman Smith, Vice Chairwoman Key, and distinguished members of the Judiciary Committee. My name is Jennifer Huddleston, and I am a research fellow with the Mercatus Center at George Mason University, where my research focuses on the intersection of law and technology, including issues related to data privacy and data protection. Thank you for the opportunity to provide testimony today regarding my research and its relation to the regulation of search and seizure. In this testimony, I plan to cover 3 key points. First, clarifying the requirements for government to obtain access to electronic information can be an important and appropriate role for states in protecting their citizens' civil liberties. Second, that establishing statutory requirements for access by the government to electronic information reflects both the original intentions of such protections from search and seizures and limits the disruption of innovation by preventing potential abuses while still enabling justified use of technology by law enforcement and others. And finally, the importance for policymakers in avoiding potential spillover effects and unintended consequences beyond the search and seizure context when it comes to the government's use of widely available technology and the future of innovation in general.
If I could just interrupt for a moment, I see where you are after point number 3. I assure you that not only can everybody on the committee read, but we will read the
Yes, ma'am.
testimony. So if you could summarize
Yes, ma'am.
and help us understand the key points, that would make it easier for us to understand the written
Yes, ma'am.
testimony.
I will.
Thank you.
Are you supporting this bill?
We provide educational information, so we neither support nor.
Thank you.
May I continue?
Yes, please
So to
do.
begin with, these type of bills are distinct from the type of data privacy bills we're seeing out of states like California, which are broad-based consumer privacy bills that are largely affecting the interaction between a consumer and a company. So you may have heard about the California Consumer Privacy Act, or CCPA. There are a lot of concerns about the potential constitutionality of bills like that, particularly if related to the Dormant Commerce Clause. When consumer is defined very broadly and there are broad data privacy regulation at a state level, there's quite likely that it could spill over and have effects on a more national level that may be unintended or may not align with other states' preferences. Additionally, those bills raise other constitutional concerns, such as First Amendment considerations, and also the potential to conflict with the system of law. In contrast, bills regarding the access to third-party information and electronic search and seizure are more of an interstate issue. It's the government restraining its own ability and to access different information, and it's also a case where states are actually having the opportunity to act as a leader. They're extending what the Supreme Court started in Carpenter by identifying that some technological changes may have raised questions about the third-party document. In the past, when you handed a bank teller a piece of paper, or you went into a phone booth and dialed a number, you were aware that you were sharing that information with a third party. Today, a lot of times the data that may have been able to be accessed under the third-party doctrine is much more passive. There isn't that same understanding. So last legislative session, Utah, looking at Carpenter and looking at kind of the way technology was evolving, has the first of its kind law that established warrant level protection for all electronic data. In some ways, this is expanding on the way the federal government has been heading, but also reflecting the traditional trajectory. This bill would have a similar impact on the potential for protecting individual civil liberties, but it still allows law enforcement and government to get that information if they go through the appropriate steps, such as obtaining a warrant. Such bills are likely to become increasingly important in an increasingly connected world. So, in a flexible approach that addresses not only the concerns regarding our current data situation, things like email or cell phones, or some of the other examples like the cloud that have even been brought up today. They also can impact things like driverless cars that would be able to transmit location data, or IoT devices, or many of us who are already wearing smartwatches, Fitbits, Apple Watches, and the information that's collected there on an incidental account. It also, though, however, enables law enforcement to access that information when it is valuable. It still allows the obtaining of a warrant. And so there are cases that we have seen where technology helps law enforcement either eliminate potentially someone who's wrongly accused or provide detailed information such as a time of death. It also, there are cases where this data would be useful for under a search warrant, even if it is something like cell phone location information. So for example, in the Carpenter case, the court didn't say that law enforcement or government never obtained cell site location information. It merely said that that information was subject to Fourth Amendment protection. Rather than listing every technology that currently exists, a more flexible approach that addresses the underlying principles behind why the third-party doctrine might not make sense in certain situations will allow the law to adapt to new technologies that we might not be able to even. Now, at the same time, it's important to think about the potential for unintended consequences beyond just the scope of search and seizure. Certainly, we don't want a situation where government or law enforcement is unfairly handicapped and unable to use new technologies that could be incredibly useful for, say, finding a missing child, or for other positive, benevolent purposes, but at the same time, we want to ensure that there are appropriate balances on maintaining citizens' civil liberties. Again, addressing the underlying principles there, as well as looking at narrowly tailoring specific use cases if there is a need for additional regulation of preventing law enforcement or government to use certain technologies. This has become a debate not only in the access to electronic information, but on a variety of technologies such as GPS locations and facial recognition, and it's certainly likely to become an increasing conversation as we see a more connected future. Also, the language here matters, and there are a lot of questions about how this could potentially spill over. So for example, the concept of owning your data may sound wonderful in a law enforcement context. And it's also one of those things that oftentimes, particularly for those of us that are attorneys, is an easy concept to think we grasp. But data doesn't follow the traditional rules of property. It rarely is owned or created or has that bundle of sticks and rights with one single individual. So we should be cautious about saying things like owning the data, even in other contexts, so that that doesn't spill over and have unintended consequences on the future of innovation and some potentially really beneficial uses of data. Data privacy is a multifaceted issue. Oftentimes we hear about it in the context of data breaches or consumer rights, but this is another example of where the government and policymakers need to carefully consider how technology may be evolving and whether or not the law as it currently is sufficient or if it needs to evolve along with technology. By establishing a framework for government access to electronic data, as with other issues in technology, it is an important opportunity for states to act as a leader and provide greater clarity to consumers, innovators, and government actors on this emerging issue and appropriately balance civil liberties as well as the future of technology. I thank you for your time and I welcome your questions.
Thank you very much for your substantive testimony. I believe Representative Griffin has a question?
I did, but I'm wondering what, I'm gonna ask you and maybe another party. Thank you very much for your testimony and your knowledge of the issue. On the first page of the written version of the testimony that you're giving us, you pointed out that part of dealing with this is establishing statutory requirements for access. The bill in front of us, while being enacted in the statutory process, is actually a constitutional amendment. I understand from the sponsor of the bill, he worked more closely with another organization in drafting this. Do you have a position as to this being a constitutional amendment as compared to statutory?
No, ma'am, I don't.
Thank you.
Thank you for that question. Are there any other questions? Not seeing any again, I thank you for taking the time to come here and to share your deep knowledge with us. The chair recognizes Amy, is it P or Pi?
P.
Amy Peacock, coming from California, Orange, California, the Center for the Legalization of Privacy. Thank you, and I believe you have distributed. You distributed your testimony.
Written testimony. And with your permission, I might read a little bit of it and then skip over some of it. It's quite short. So
Terrific. Thank you very much.
Take any questions as well. Thank you, Chairwoman Smith and the committee for allowing me to come and speak here today. I'm from California, but I actually lived in Nashua for 3 years.
And why did you ever leave?
I was a child, I didn't have a choice, so I just plead that.
Well, we believe in choice in all times in New Hampshire, so you can
That's
back
very
anytime.
good, because that's what I'm about here, is I'm about giving New Hampshire citizens as much choice as possible. I like to think that my 5th grade teacher at Maine Dunstable Elementary School in Nashua, his name was Mr. Levesque, and he was very forward-looking. I don't want to tell you how forward, because I might be dating myself, but he allowed the girls who wanted to play football with the boys and him during recess to join in, and so I was one of 2 that got that experience repeatedly, and I like to think that he's a small part of why I'm here today, and that would keep me happy about it, but didn't want to say we'll see. So as I said, thank you for giving me this opportunity. As I'm going to explain, CACR15 presents an opportunity for New Hampshire to lead the way in restoring crucial constitutional protections for individuals, while, importantly, at the same time, preserving government's ability to engage in legitimate criminal investigations. In my view, a pillar of a free society and limited government is that law enforcement must obtain a warrant based on both probable cause and particularized suspicion before accessing citizens' private data. And I don't think it's a partisan issue at all. I think both sides could agree on this. And yet, we've been deprived of this basic protection since the 1970s. Why? This is because the United States Supreme Court unjustifiably expanded this third-party doctrine that we've been talking about. The doctrine now says that once you share information with a third party, and this is not just an electronic data issue, this is any kind of third party. Once you share information with a third party, you no longer have what's called a reasonable expectation of privacy in that data, and consequently that information no longer enjoys the Fourth Amendment's warrant requirement protection. That's the way the doctrine is currently interpreted. Now, in a couple paragraphs here, I talk about the history of this. The third-party doctrine did not just spring up in the 1970s, and unfortunately, in some of the opinions in the Carpenter case from 2018, even justices talk about the origin of this doctrine in the 1970s. It did not come to be in the 1970s. It had been in effect for decades, but for decades, that doctrine had only been in what's called the secret agent cases. And the secret agent cases involved what the representatives were discussing with Representative Yokela up here, involved illegal contracts, okay? And in an illegal contract, it's not enforceable. So if you have your agreement about the Coca-Cola formula that you stole and you're gonna go make it some money off of the secret formula, that contract is not enforceable. Neither is any side agreement that you have to keep out all the information that you share secret. So if you have an unenforceable contract, it makes sense that if you share information as part of that contract, the government can obtain it without a warrant. The government is not violating anybody's rights. And if anybody on the committee is familiar with the history of the Fourth Amendment and the way it's been construed at the federal level at least, it used to be that they would look at trespass as an indication of whether there had been a violation of the citizens' rights under the Fourth Amendment. If there had been an unreasonable search and seizure, law enforcement had committed a trespass. Today we don't really talk about trespass. I agree with Ms. Huddleston about the fact that speaking of data as being owned is not necessarily helpful. But what we see today is that a lot of our information, a lot of the private information about us is shared in the context of a contract that I have with Facebook, with my bank, with my internet service provider, my cell phone service provider, my grocery store. You go to the grocery store and you get the little, those here, right, the little membership cards we have in California, the grocery store. They collect all kinds of information about you and your shopping habits that way. So we are constantly sharing information with third parties, and so what we're looking at now is, whereas our privacy used to be primarily protected through property, now it is primarily protected through contract. And because of this detour that the Supreme Court took in the 1970s, those contracts are not being enforced so as to protect our privacy. We still have privacy in our homes, but I don't think the Supreme Court realized the ramifications of transporting the third-party doctrine into the ordinary contractual situation. We are not criminals. We have not gone to Coca-Cola and stolen the secret formula and engaged in some scheme to go ahead and make some money off of it. All we do is we go to Facebook and we want to share our cat pictures and our cute kid pictures. Or we want to just have cell phone service and drive around and be able to actually know where we're going because we've all become dependent on the GPS device, etc., right? We are just ordinary citizens trying to take advantage of all the wonderful goods and services, some of them electronic, some of them not, that enrich our lives. And we don't believe that we should have to give up Fourth Amendment warrant protection for private things about us in order to do that. That's really what this is about, because today privacy is protected as much, if not more, by a contractual arrangement than it has been historically through property rights. And so this is just really restoring the sort of expectation of privacy that citizens have via the language that is necessary to do this. Now with CACR15, individuals will be permitted to share information for limited purpose while still enjoying robust warrant requirement protection. It will not burden private individuals or businesses. It's a limitation on law enforcement only. So, sir, when you spoke about Canada, the limitation is not on a Canadian service provider. It's on law enforcement. But law enforcement may not go and obtain that or demand it unless they can present a warrant. So it would, any provider, service provider, provider of goods who was contracting with a New Hampshire citizen, and you had New Hampshire law enforcement trying to go to that provider and get the information, they would have to provide a warrant. They can still get the information from the provider, but they have to provide a warrant under CACR. Now, at the same time, the precise language that we have in the provision, which Representative Drapilla and I worked on, it excludes data shared as part of an illegal contractual arrangement. And that is not going to enjoy warrant protection, okay? So the original impetus for the third-party doctrine, I think, was well-intentioned. It said, if you're engaged in a criminal scheme, the contract that you are making with your cohorts is not enforceable. And that includes any side agreements to keep the information private. I believe that was the actual rationale for the third-party doctrine, although it wasn't stated explicitly. It is rooted in our common law. So accordingly, CACR 15 is worded to provide the increased protection only for legal contracts of ordinary citizens. Again, it is worded so as to correct this detour that the Supreme Court took in the 1970s in Smith and Miller. And so, yes, I would say Smith was wrongly decided. Not because I think that people should be able to harass others with phone calls or what the bad guy was doing in that case, right? But that the contract that you have with the telephone company is not itself an illegal contract. And so what law enforcement should have to do is provide a warrant based on probable cause and particular suspicion, which they may well have been able to do in the Smith case. If you look at the facts of Smith, I think they may have been able to get a warrant, but they just didn't bother to. A lot of these cases, it's just because they didn't get the proper warrant that they needed. So that's all we're asking, is that police get a warrant in order to induce what would otherwise be a breach of contract with a customer in a perfectly legal contractual arrangement. So what will it do? It will reinstate CACR 15. It will reinstate the bright line that I believe the Supreme Court erased in the 1970s. And this is the line between criminals who are making illegal contracts, which should not be enforced, and contracts that are made by law-abiding citizens, which should be. So CACR 15 will actually be unlike what Utah or anybody else has been doing on this issue. You have an opportunity here to be a leader and provide New Hampshire citizens first with protection that should have been here all along. So I'm happy to answer any questions.
Thank you very much. Representative Griffin.
Thank you, Madam Chair. Thank you for taking my question. You just pointed out a distinction as to this bill in Utah and California. Utah and California, they are statutory enactments of this protection as compared to this, which is...
Well, California hasn't done anything like this yet. The California Consumer Protection Privacy is different from this. That is actually a restriction on what corporations may do with your... So
understood, but they're both statutory provisions as compared to
Okay,
constitutional.
Mm-hmm.
And I think we heard earlier that one of the glories of new constitutional provisions is that we get to have lots of court cases to decide exactly what it means, right? So
Yes.
could it be thought that perhaps Utah took the more logical approach to this to provide specific guidance as to what was protected and not protected as compared to this conundrum where as a group of fairly learned persons we can't even agree on what provided meant?
Well, I think we could talk about what provided meant, and I think provided and shared are quite similar, and I want to ask what
I'm sorry, I don't need to
Sure.
to
What the
get
representative
sidetracked.
thinks for sure. But I actually think the situation is the opposite of what you're worried about. because I think that Utah, in getting rid of the third-party doctrine entirely, in essence, that's what they've done. The only thing that they've done is they've allowed an exception for imminent danger. I think that they are the ones who are going to have the court cases clarifying their language. Because what if they have a case involving an illegal scheme like the case we're talking about? You steal the Coca-Cola formula. The situation, the hypothetical that I have is a bunch of scumbags start a Telegram group for sharing child pornography. And they have this deal, I've got this great child pornography and I'm gonna share it with you as long as you share all the best stuff that you've got with me. These are some bad guys. But suppose a government agent gets himself invited to this Telegram group and poses as a scumbag and, gets information about these people and then reveals it to law enforcement that there's never been any warrant. What is Utah gonna do with that case, right? Because there's not an imminent threat to anybody, so is it gonna fall under the imminent exigent circumstances exception that they're gonna allow? I would say it is a much better, scenario if we are clear that we're gonna say that arrangement that those scumbags have made in their Telegram group is not a legally enforceable contract because they're engaged in illegal conduct. It's for an illegal purpose. And so I think by wording it this way, although, I understand there's some questions about why exactly this language and the third-party doctrine itself makes people's eyes glaze over, this is very precise language geared to permit and permit choice to, and to protect the rights of law-abiding citizens, while at the same time allowing law enforcement to infiltrate criminal schemes, put secret agents in there, go after scumbags. In the electronic version of this testimony, which I think has been emailed to all of you, I've got a hyperlink to a law review article in which I explain the rationale behind drawing that distinction between illegal contracts and illegal contracts as the basis for where the Supreme Court went wrong with the third-party doctrine. And that might be clarifying as well. But I actually think that you will have less problems interpreting the language in this scenario than with Utah, and even Arizona arguably in their litigation has attempted to blanket, get rid of the third-party doctrine entirely. What are they going to do with these illegal contract situations where there's not an imminent risk of bodily or other significant harm?
Thank you. Thank you. Are there any other questions?
Yeah.
Representative Wilbur has a question.
So I thought, maybe I just don't know what's going on. So the question I have is the same question was asked earlier. Why is this a constitutional amendment as opposed to statute law?
Okay, I think that a constitutional amendment is the only way to restore a constitutional protection that has been withdrawn from citizens, like I said, since the 1970s. If you were going to either offer some sort of a clarification to another constitutional provision that was only legislative, then the next batch of legislators could change their mind and offer a different clarification, then suddenly this crucial protection would be gone. Again, I believe a pillar of a free society and limited government is that law enforcement needs to get a warrant. There needs to be probable cause and particularized suspicion before you allow access, government access, to the private data of citizens. And the only way to guarantee that as firmly as possible, right? Because even a constitutional amendment is not sacrosanct forever. It can be changed later, but it's a lot harder to change. It is the best that we as human beings providing government to protect citizens' rights can do, the constitutional amendment. So as strong protection as possible that you could provide in restoring this for your citizens, I think is the best way to go.
Thank you very much. Representative Gordon has a question.
Again, get back to the language. Part of it says legally enforceable contract that is to be used only for a limited purpose. that is to be used only for limited purpose, apply to the information or to
Yes,
the content?
yes. And so if we went back to grammar school
That's
and
not
diagrammed
grammatically
that, we would know that the use for limited purpose is going to apply to information. Yes.
That's not grammatically correct as it's written.
You think it's not, so
Well,
you think we need to make modifications?
I think it modifies the contract.
I believe that you have two modifying clauses of information. And so one of them is that it's provided as part of a legally enforceable contract, and then the second modification is that it's to be used only for a limited purpose. But
The
I think,
information is to be used only for.
yes, and otherwise kept confidential.
So to follow up, Madam Chair, so to be correct, would that not say including information that is to be used only for a limited purpose, provided as part of a legally enforceable contract?
So you would want to displace the clause, or you put a comma in, you think it's unclear the way it is because of the.
Well, I guess I'm just going back to English class, it's saying the sentence structure is grammatically correct.
Thank you for that. I never diagrammed a sentence in my life, but I was a product of progressive education. Are there any other questions? Yes, Representative Gordon.
So, we would modify the New Hampshire Constitution, and under New Hampshire law, under general any law, the state is entitled to have a constitution that provides more protection than the federal constitution. So, in federal cases, how will that apply to federal cases? This would affect New Hampshire law enforcement.
Yes.
How would it affect federal law enforcement dealing with matters?
Yeah, and you're not going to be able to restrict the conduct of federal law enforcement agents. You will be able to restrict, of course, the New Hampshire law enforcement agents, but I do think that it will also set an important precedent such that combined with what we've seen in Carpenter, where the Supreme Court is already trying to put a limitation on the third-party doctrine, they're moving in that direction. I think that at some point, we're gonna see more and more states do this, and eventually there will be restrictions on the federal level as well. At least that's my hope.
Thank you very much. Are there any other questions? If not, again, thank you for taking the time to be here. I appreciate it very much. The chair recognizes the final speaker, Dan Itzy, who is going to be unbelievably brief since this committee has a 1 o'clock.
We're going to see me again. But being that as it may, one, I want to compliment the drafters. While I understand Representative Gordon's position about the juxtaposition of limited purpose, I think he may well be right. The fact that the language is so brief and general, I think is great, as opposed to the amendment to Part 1, Article 8 last year, which I thought was overly verbose. To Representative Gordon's question regarding the letter from the U.S. Postal Service and the recipient, the issue is not the sender or the recipient. The issue is the U.S. Postal Service, which is in between where the information lies for a time. Now, in our current situation, information in the hands of the U.S. Postal Service is in fact protected. Furthermore, a better comparison would be if you sent your letter via UPS. But then imagine that letter that you sent by UPS by their nature makes a copy of it and keeps that copy. And we're talking about the access to that copy that UPS keeps. And they said they're going to keep it confidential, but right now it can be obtained by subpoena and not by a warrant for a particular purpose on presumption of the crime. And that's the real issue of where we are. The problem is that now all the things that we used to send as hard copy and didn't exist somewhere out there are now subject to being obtained by the government, not through the sender or the receiver, but out in the ether, if you will. As to Representative Chase's question, no, this would not protect the shooter, and I think it would give greater clarity as to what Apple was obligated to do, because pursuant to a search warrant, Apple could no longer hide behind it, because we say that information can be obtained by a search warrant. So it gives very positive direction. I think it absolutely ought to be a constitutional amendment, because we are talking about personal, private information and how an individual's privacy in regard to that relative to the government. And it provides the framework in which you will all eventually write statutes that say how the government goes about getting it. On a more general level, the Constitution of the United States has, in Part 1, Article 1, Section 10, a prohibition on the states. And it says, among other things, that no state shall pass any law impairing the obligation of contracts. So you can't pass a law that changes a standing contract. This extends that prohibition not only upon the legislature, but on the executive and judicial branches. You can't just go out, they will not be able to go out and willy-nilly invade the presumed privacy of an established legal contract. So it's extending that idea that the state government can't impair existing legal contracts.
Thank you.
And I want to just show you one thing. See, this is an antiquated cell phone. I keep it because it is the last cell phone that I can update my contacts between my computer and my cell phone without putting the data to the cloud. And that's why I go to great extent. This phone protects my privacy. I do not put my pictures nor any of your addresses and your connection to me into the cloud. I keep it only between my phone and my computer.
And your car, thank you very much. Any other questions? If not, thank you very much. This closes the hearing on CACR 15. Are those people in the room here for the next